Welcome back to yet another video. Hi, I'm Advocate Manjit. In today's video, I'll be talking about what exactly is a legal notice and what are the things that you really need to keep in mind while you're drafting and sending in a legal notice. Now here, there could be two situations. One being that the client comes to you, tells you about a dispute that he or she is having with a third party and would ask you to send in a legal notice to the other party on their behalf. Now here, the client coming to you may not directly tell you that they really want you to send in a legal notice. They would probably just tell you about the dispute. As an advocate, as a legal advisor, you would need to tell the other party that the first thing that they would need to do is to send in a legal notice to the other party, asking them to, reply back with what their contentions are and probably try to settle the dispute out of court. That's the first thing that you will have to do. So this is actually a notice that you would be sending on behalf of your client. The other situation could be your client has already received a notice regarding a dispute with a third party that the lawyer of the third party sent out to your client, and he will come to you giving you the notice and asking you what exactly needs to be done. So here again, you would need to advise your client that you will need to first reply to the notice that the other person has sent out to your client. So that's called as a reply notice. Now, whether it's a reply or a notice reply that you are sending out on behalf of your client, you would need to mention all the details which are really relevant to the dispute that your client is referring to with the other party in details as well. So you really can't miss out on the important aspects of the dispute and not mention that in your notice or your reply notice. That's mandatory that you key down all of the important details that your client has shared out with you. So to give you an example, if the dispute is between a tenant and the landlord, so when you're sending in the notice or the reply notice, you really would need to mention all the details regarding what exactly was the type of the instrument executed between both the parties, when was that done, was it registered, when exactly was it registered, has the tenant been paying the rent on time, if not, for how many months has he defaulted, what exactly is the concern between the two parties, what exactly is the dispute, when exactly the cause of action arose. So all of those details have to be mentioned in the notice. The other example could be that of a dispute between a married couple. So you will have to note down all the details regarding when exactly did they meet, where did they meet, or when did they get married, according to what act or according to what traditions did the marriage get solemnized, where exactly have they been living together, do they have any issues, that is children, what exactly is the dispute between both of them, when did the dispute start, have they been living separately, since when have they been living separately. So all of these important things which are really key to the dispute between both the parties have to be noted down in your notice or your reply notice. Now, one important thing that you need to keep in mind, especially while you're drafting the reply notice, is apart from what your contentions are on behalf of your client, you would also need to reply to the notice para-wise. So you'll have to acknowledge, all that is written in the notice sent out to your client. You will have to give them a reply para-wise or whatever they have said in their notice while you are drafting the reply notice on behalf of your client. Apart from, of course, whatever you have to say additionally in the reply notice, that is something you will definitely mention. But you would have to reply to the notice para-wise also. Now, apart from the notice as well as the reply notice, there's something called as a rejoinder notice as well. So what exactly is a rejoinder notice? Now, for example, I've sent in a notice on behalf of my client to a third party. They engage a lawyer, then probably send in a reply notice back to me. Now, on the instructions of my client, I want to add something, or modify something, or probably reply to something, that the other party has said in their reply notice. So basically, anything that I've missed out or probably want to add on, which I've not really said before in my notice, I want to state that and send a notice again out to the other party. That's called as a rejoinder notice. So you have the notice, the reply notice, and a rejoinder notice, which is nothing but kind of a supplement to the original notice that you've sent out in the first stage. Now the notice, the reply notice, or the rejoinder notice that you're sending out, as the case may be, have to be printed out on your letterhead, the advocate's letterhead, and it would also need to bear your signature as the advocate for your client. The language of your notice, the reply notice or the rejoinder notice would be that on the instructions of my client, on behalf of my client, and my client states that, or my client says that, because whatever you are saying in the notice is on behalf of your client. That is not something that you are sending, by your own will. You are sending it on the instructions of your client, so you have to specifically mention that in your notice, reply notice or the rejoinder notice as well. Another important thing is the notice, of course, would bear your signature, as I just mentioned, as an advocate for your client. At the same time, it is not really mandatory to ask your client to, sign on all the notice, reply notice or the rejoinder notice. However, if any of these, the notice, reply notice or the rejoinder notice, contains allegations against the other party, you are alleging the other party of certain things on behalf of your client, then of course it is advisable that you ask your client to put his or her signature on the notice as well, because you really wouldn't want your client in future to deny and say that this is not what he or she had instructed you to do as an advocate on their behalf, and you've probably drafted the notice according to your whims and fancies. So you will take the signature of your client on the notice along with your signature, of course, on the notice, if your notice has a lot of allegations that you have framed against the other party, of course on the basis of what your client has told you or instructed you to do. Another important thing is, in case the notice is drafted in a language which your client does not understand, so below the notice you will have to clearly mention that you have read out the notice to your client in a language that he or she understands, and ask your client to put down his or her signature there as well. So be it a notice, a reply notice or a rejoinder notice, as I've already mentioned, that you will need to take a print out of that on your letterhead as an advocate and send it out to the other party. Now if there are more than one party that you need to send out the notice to, so you would send the original one to the main party. At the same time, you would send out copies of the notice to the other recipients as well, to the other parties to the dispute as well. Sending in the notice, the reply notice or the rejoinder notice, one important thing is you need to send it out via RPAD only, which is registered post acknowledgement due, that falls under Indian Postal Services, because that is something that is recognized by courts and given priority over any other mode of sending in the notice. So make sure that you do it via RPAD. When you do the RPAD, you would get a slip basically having the tracking number. You need to maintain and retain that original slip that is given out to you, because that again is a piece of evidence that would be used out in future as this dispute to go into the court of law. Another important thing is you get that slip, so you will have to go on to the internet on the Indian Postal Services website and track the consignment with the number. So there is an alphanumeric number on the slip that's given out to you, starting with RN followed by a couple of numbers and ending with IN. So that's the tracking number you will have to put in on the website. Track it, so you'll have the tracking history, when exactly did you send it out, and what exactly happened. Was it delivered, on what day, what time was it delivered, or was it returned back to you for any XYZ reason. So all of that history is mentioned on that website, so you will need to take a printout of that as well, because this information that is available on the website is only available for a period of 3 months. So at a later stage, when you're trying to retrieve this information from the internet, you may not be able to do so, and perhaps this tracking history, the printout that you're taking out from the net, is also something that would work as a piece of evidence in future if this dispute materializes into a suit. Now, a copy of the notice, the receipt or the slip that you've gotten from the postal services, the acknowledgement slip that you received, at the same time the tracking history, the printout of which you've taken out from the net, all of these things have to be maintained and preserved in the client's brief for your own records. At the same time, you would supply a copy of the notice as well to your client for his or her reference, and all these things would be, as I mentioned earlier, would be a piece of evidence if this dispute eventually went out to take a shape of a suit and is filed in the court of law. So that's all about what a notice is, what are the key things that you need to keep in mind while you're drafting notices, and how exactly is the method of sending out the notice. I have covered only the basic things that you need to know while you're drafting and sending in legal notices. Of course, the video does not encompasses everything that's related to a legal notice, but I'm just trying to cover up the basics that you need to know before you can even start writing a notice or drafting a legal notice on behalf of your client. I hope you find this useful, and I've been able to cover up the basic important things that you might have questions regarding. Please like, share and subscribe to my channel to keep me motivated so that I bring more videos to you guys. Also press the bell icon to receive the notification of my videos. Do mention comments in the comment section as well to keep it more engaging as well, and also with your feedback that you have for me in the comment section. I'll see you all in my next video. Till then, keep learning.